Hello friends, Namaskar. Are you contesting a case under the Prevention of Corruption Act? Are you having certain issues? So, in the present class, I am going to give you an appropriate solution. While contesting a case under Prevention of Corruption Act, what do you think? The case is causing panic to you, or you may contest the case. If you are thinking that the case is going to panic you, then you could not be succeeded. But if you think that you could easily contest the same, then you may be succeeded. But apart from that, you must be able to understand the basis of law, how to contest these cases so that you could secure an acquittal. Do you know when we contest cases under Prevention of Corruption Act, we follow an orthodox pattern. Visit the office of lawyer, give the file. Vakil Sahab, please read the file. I will back soon. But whether you back soon, never you back soon. When you call, your counsel might be busy. And when you call again, he might be again busy. But the busyness can cause a panic to you in your case. While going to a lawyer, you must be prepared with your case and must know the basis of your case. Concerning same, we are having ample guidelines of Honorable Supreme Court, Honorable High Court. We all know that if we are having a trap case in which the demand is sine qua non, the acceptance, the recovery plays an important role, the complainant, co-complainant statement plays an important role, the statement of shadow witness plays an important role. But are we serious about our case? The answer is no. We are adopting the approach that is totally out of syllabus. We have to update ourselves, we have to update our information so that we could easily contest the case. Are you ready? If you are ready, then please maintain a notebook with a pen or pencil. And I am going to initiate from the basic principle of BNI. BNI is basically a group of businessmen wherein the basic principle is given to them. That is the learning process. And learning doesn't mean the general learning because we believe that knowledge is power. But the concept is wrong. Execution of proper knowledge is the power. So it is the right time to execute the things in the proper perspective. First of all, I request all of you just narrate the charges labeled upon you by the concerned anti-corruption bureau or vigilance or by the concerned authority. In a trap case, we are facing charges as per 7.13.1d of PC Act or 7.13.1b of PC Act or 7.13.1b PC Act along with 384 of IPC. But the point is that whenever having such type of issues, what we are doing, just going to office of advocate and giving the fine. But we have to change this pattern. We are the master of our own fates. So first read the FIR. I will discuss with all of you the success story of one of the accused who got an acquittal in a case under Prevention of Corruption Act. First of all, I want to introduce you with the name of that person. The case is J.S. Yadav versus State of MP. It is propounded by Honorable MP High Court and the appeal number is 130/2016. In that case, the concerned complainant approached the local with a request that I am running a pickup on commercial basis. On one of the fine day, my vehicle was intercepted by the police. I requested them to release the vehicle, but the concerned SHO of the PS submitted that if I want my vehicle back on the road, I have to pay rupees 10,000 as a bribe. The amount is unjustified. I am not willing to pay the same. Please lodge the FIR and proceed against such corrupt officials. I think that you are having the similar story in your case. Facts might be different, but modus is same. For a certain work, you had demanded money from the complainant. It is the basic submission of the complainant to the concerned Lokayukt or vigilance or ACB. And the concerned authorities are having the same process, giving the tape record. Oh boy, just go and have the recording. And along with that boy means complainant, shadow witness, who is nothing but one of the official of department is sent along with. And after the back, oh my god, there is a recording in which it is clear that accused is demanding the money. Is it a verification? Do you think? It is not a verification, but authorities are going to play with the compliances. I'm going to remember one of the most important judgment of Honorable Supreme Court, that is Lalita Kumari versus State of UP. Judgment is pronounced on 12th of November 2013. In that case, it is specified that make inquiries to find out whether a prima facie case is made out or not. But what they are doing? Nothing. Giving the tape recorder, go, 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 and take voice, voice, voice. But they are doing nothing to verify. And sometimes it is seen that there is no pendency. But despite of that, they used to lodge the FIR, they used to proceed and used to trap the accused. Sometimes the accused demanded only. There is no acceptance recovery. But despite of that, no benefit of section 17A of PCA is given. They are emphasizing to arrest the accused, even in case as per section 7 of PCA. But do you know, in the consent charge, we are having the maximum imprisonment of 7 years. But despite of that, no benefit of section 41A of CRPC or section 35 subclause 3 of BNSS is given. Why? Are the authorities above the Supreme Court, above the law, above the High Court? If no, then why they are adopting their own process? The great question mark. In that case, the accused was charge sheeted, and in your case, you are charge sheeted. Same story. Apart from that, the accused was convicted. You might have a trial pending, but the key point is that have the proper study of your case, make a proper review, find out the inconsistency in the statement of complainant, co-complainant, shadow witness. If they are inconsistent, then we could have the benefit. The key point is that for the prosecution of the accused as per section 7 of the PC Act, demand is signed going on. If demand is not on the record, in that scenario the accused could not be convicted. And apart from that, what are the version of concerned complainant and shadow witnesses? If they are going to narrate a different story, their statement are self-inconsistent, in that scenario we could have the benefit as taken by that accused in that case. In that case, the complainant denied regarding the demand by the concerned accused. And apart from that, the shadow witness submitted that he was standing outside, and that's why he was totally unable to hear the alleged conversation allegedly occurred between the complainant and the accused. So, it is a case of mismatch. And apart from that, there is no one who could corroborate the case as an eyewitness. So, when there is no direct evidence, how the case could be proved? With the help of circumstantial evidences, as observed by Honorable Supreme Court in judgment of Neeraj Datta versus State of NCT. Judgment date is 15th of December 2022. So, in that scenario, we have to follow the guidelines of Honorable Supreme Court, which is propounded in a case titled as Sharat Birdi Chand versus State of Maharashtra. Citation is 1984 SCC page 110. In that case, court specified that if a case is based on circumstantial evidence, the prosecution has to complete a complete chain, has to specify the motive, but the test is much higher as compared to the case of direct evidence. A mere breakage, a mere doubt can dash the case of prosecution to the ground. Prosecution has to travel between maybe to must be. If they are not able, then they have to face the consequences. Weakness of defense, weak defense, no defense cannot be a ground to assume that prosecution is succeeded. Apart from that, in the present case, the transcription is mismatched. There is no specific demand. You have to see in your case also. And apart from that, there is no corroboration. The evidences are inconsistent. And apart from that, the manner of doing the chemical test, the manner of recovery, and apart from that, the material circumstances are inconsistent. So, the court drawn the adverse inference against the prosecution and finally accused secure and acquittal. So, whenever we are going to contest a case, first read the FIR, then read the verification, then read the transcription of verification, then listen the audio recording if there is no specific demand. But despite of that, it is shown that accused had demanded, put a question mark. And you have to see whether the alleged transcription is prepared in the presence of independent witness or not. If not, then we could have the benefit. Apart from that, we have to see in which manner voice is recognized or identified. And apart from that, we have to see in which manner sample had been taken, whether there is due compliance of section 349 of B and SS or not. We have to see the trap proceeding. We have to see when the chemical test had been occurred. We have to see the implication of rule number 47 of CBC guidelines. And apart from that, we have to see whether the sanction is as per the protocol of guidelines of Honorable Supreme Court judgment CBI versus Ashok Kumar Agarwal, that is propounded on 31st of October 2013. Then we could secure an acquittal. So I request all of you to leave the casual approach to avoid casualty in your case. Update your information and read much updated information. You have to be acquainted with legal compliances, must be acquainted with your facts, and have to see the violations in light of both the legal compliances information and facts, so that you could secure an acquittal in your case effectively without any panic or worry. So I think that I am totally able to cause all of you to understand the basis to secure acquittal in a false case under Prevention of Corruption Act. See you in the next video. Till then, Jai Hind, Jai Bharat.